Tonight he smiled like he'd already won. Like the judge's gavel was just a formality. Like my life was a suitcase he'd already packed for me. He leaned back in his chair, polished shoes crossed, and said softly, "You'll take what you're offered, and you'll be grateful." I remember my hands shaking around a paper cup of courthouse coffee, bitter, burnt, and somehow still not as bitter as the line he'd just drawn. Because the thing about my ex-husband, Grant Holloway, was this. He didn't just want to leave me. He wanted to erase me. And when I realized he was hiding assets, not just a little, but like a magician hiding an entire stage, I decided I'd stop being the assistant in his trick. I'd be the one pulling the curtain. We were in King County Superior Court in Seattle, 3 months after he moved out with a duffel bag and the confidence of a man who'd rehearsed his story in the mirror. The petition said irreconcilable differences. His tone said inevitable defeat. But the first clue that something was wrong didn't come from his smug face. It came from my mailbox, a plain white envelope, no logo, no letterhead, just my name typed with the kind of precision you see on legal mail. Inside was a single page, folded into thirds. Notice of lien, filing pending verification. It read, not addressed to me exactly, addressed to Holloway Holdings LLC. And the property listed wasn't the condo he'd moved into. It was our house, my house, the one I was still paying the mortgage on. In minute one of this nightmare, that paper became my legal and financial anchor. Because you can survive betrayal in your heart, but betrayal in your credit file is a different kind of violence. I called the number at the bottom. A bored-sounding clerk in a title company's compliance department answered. She confirmed what I feared. There was an LLC formed 6 weeks earlier, with my ex listed as manager, and there was activity. Preliminary title work, she said, possible transfer or financing. My stomach did that slow drop, like a roller coaster you didn't choose to ride. Is my name on it? I asked. Ma'am, I can't disclose. Is my name on it? I repeated, sharper. A pause. No. Then softer, almost kind. It doesn't appear so. Grant was trying to move money without moving in the light, trying to drain equity while smiling in court about simple division, trying to sell my future by the inch. I didn't confront him right away. I did what women learn to do when the world calls them emotional. I collected facts. I opened a spreadsheet, every account I knew, every payment I'd made, every weird withdrawal I'd ignored, because I trusted him. I pulled my free annual credit report and then paid for a monitoring service that showed more detail, faster. I printed bank statements from the joint account that was now only joint in the way a battlefield is shared. I looked for patterns, and I found them. Every month, 2 days after his paycheck hit, there was a transfer. Not huge, not flashy. $1,950, $2,100, $1,875, always under the kind of number that makes people shrug. The recipient? A business name I didn't recognize. Northline Logistics. At first glance, it could have been a vendor, a contractor, something boring. But boredom is exactly what scammers dress in. I Googled it. Nothing. No website. No reviews. No address. Just a registered agent listing in Olympia and a P.O. box. Escalation doesn't always arrive with sirens. Sometimes it arrives with a P.O. box. I drove to our old bank branch in Bellevue and asked for a manager. I said the words I'd never said before. I'm in a divorce, and I believe marital funds are being diverted. The manager's face tightened with policy, but I wasn't asking him to break rules. I was asking him to point. He told me what he could. The transfers were initiated online. Same IP address, same device fingerprint, same login, grants, and the destination account was at a different bank, a credit union, one I'd never used. That night, I went back through our tax returns. Grant always insisted on filing early, as if speed proved competence. He also insisted I didn't need to understand the Schedule K-1s or the business write-offs. "Babe, it's boring," he'd say, kissing my forehead while he kept the paperwork angled away. Now I angled it toward the lamp, and there it was, a line item on last year's return. Consulting income, Northline Logistics. Not much, just enough to exist. Just enough to seed a lie. The next escalation hit 3 days later, when I logged into our mortgage portal and saw an alert. Important. New document available. I clicked. A letter titled Payoff Request Confirmation. Not a payoff. A request for a payoff, quote, the first step before a refinance or sale. Requested by, you guessed it, Holloway Holdings, LLC. Grant hadn't asked me. He hadn't even warned me. He'd simply tried to move a $700,000 asset like it was a used sofa. I called my attorney, Dana Park, the one friend in a blazer who didn't flinch when I said, "He's hiding things." Dana listened, really listened, then said, "We're going to treat this like forensic work." Her voice was calm, but I heard the steel underneath. "You're going to request temporary orders," I said. "Yes," she replied, "and we're going to file a motion to restrain him from transferring, encumbering, or dissipating marital assets." It sounded like language from a different universe. But it was the universe I lived in now, a universe where love became a ledger. We filed the motion the next morning. Dana attached exhibits, the lien notice, the payoff request, the LLC registration printout. We asked for an immediate financial restraining order and for expedited discovery. Grant's lawyer, a smooth man named Clifford Baines, responded with a polite sneer. "Mr. Holloway denies any intention to conceal assets," he wrote, and asserts that Miss Holloway's claims are speculative and harassing. Speculative. Like my bank statements were poetry. Like the LLC was a metaphor. At the first hearing, Grant arrived 10 minutes late. Just enough to show he controlled his own clock. He kissed Clifford's cheek like they were old friends. He didn't look at me when he sat down. When the judge asked if he understood the motion, Grant sighed and said, "Your Honor, I'm just trying to keep things orderly." Orderly. He said it like I was the mess. Dana stood and spoke in clean, sharp sentences. She pointed to the payoff request. She pointed to the transfers. She asked for temporary restrictions. Grant's side argued that it was routine business planning, that the LLC was for tax efficiency, that the transfers were consulting expenses. The judge, a woman with gray hair and tired eyes, leaned forward. "Mr. Holloway," she said, "do you have any objection to a temporary order, preventing you from moving assets until we sort this out?" Grant smiled. "None at all," he said, "because I have nothing to hide." The judge signed the order. For a moment, I exhaled. I didn't know yet that some men treat court orders like speed limits, suggestions for other people. The next 3 weeks were a slow burn escalation. Discovery requests, subpoenas, deadlines. Grant produced documents late. He produced them incomplete. He claimed his accountant was on vacation. He claimed the credit union had delays. Every excuse was wrapped in politeness, and every delay was a theft of time. Time is an asset, too, and he was hiding that as well. Then, one Friday afternoon, Dana called me. "Did you know you're listed as a guarantor on a line of credit?" she asked. My heart stopped, then raced to catch up. "No," I said. "A business line," she continued. $250,000. I couldn't breathe. "How?" I whispered. "It's in the UCC filings," she said. "Your name appears in the collateral description." UCC filings, Uniform Commercial Code. The paperwork world's version of fingerprints. Grant had been filing liens and encumbrances like confetti, and my name was on the glitter. Dana told me to come to her office. When I arrived, she slid a printed document across the desk. There it was, a UCC-1 financing statement, listing Northline Logistics as debtor, listing a secured party as Harbor Ridge Credit Union, collateral, all business assets, accounts receivable, and proceeds, and personal guarantee by spouse, Eleanor Holloway. My name, on a debt I didn't agree to, on a loan I didn't sign, or didn't think I'd signed. That night, I dug through my own files, old moving boxes, a folder labeled House, another labeled Taxes. At the bottom of a stack, I found a notary acknowledgement page, blank. Just a stamp and signature, dated 8 months earlier. A notary I didn't recognize. A county I'd never been to. My skin went cold, because it wasn't just hiding assets, it was forging reality. Dana's eyes didn't widen when I showed her. She'd seen worse. "We're going to request the loan file," she said, "and we're going to bring in a document examiner if we have to." She paused. "Eleanor, he may have committed fraud." I said the words slowly, like tasting poison. "My husband forged my signature?" "Possibly," she replied. "And if he did, the court will care." Grant's next move arrived the following Tuesday in the form of a cheerful email he CC'd to Dana. Subject, settlement proposal. He offered me the house, but only if I waived interest in business assets. He offered me a small cash payment, but only if I agreed to no further discovery. He offered me peace at the price of blindness. It was a trap with a bow on it. Dana didn't even let me finish reading before she said no. And she wrote back, polite and lethal. "We will not discuss settlement until full financial disclosure is complete." Grant responded with a text to me. Not to Dana, to me. Because abusers love side doors. "Stop digging," he wrote. "You're embarrassing yourself." I stared at the screen until the letters blurred. Then I typed back, one line. "Full disclosure. See you in court." My thumb hovered, and I hit send. It felt like stepping onto thin ice. But I was done staying on shore. 3 days later, the subpoena results came in. Harbor Ridge Credit Union sent a packet. Thick, heavy, smelling like toner and consequences. Danis and I sat side by side and turned pages. Loan application, personal financial statement, business plan, and then the signature pages, my name, written in a looped cursive that looked like mine, if mine had been drawn by someone watching from across the room. Close enough to fool a clerk, not close enough to fool me. There was also something else. A scanned copy of my driver's license, my real license, the one that had gone missing the previous summer for 2 days. Grant had helped me look for it. He'd looked everywhere except his own wallet. I remembered the way he'd hugged me when I found it, like he was relieved. Now I understood why. Dana leaned back, jaw tight. "We're adding fraud and sanctions," she said, "and we're notifying the credit union in writing that the guarantee is disputed." My voice came out thin. "What if they come after me anyway?" "They might try," she said, "but you have defenses, And now you have evidence. Evidence. It wasn't comfort, but it was leverage. And leverage is what turns fear into motion. The escalation that followed was faster, louder. Grant's attorney filed motions to quash subpoenas. Dana filed motions to compel. The judge issued deadlines. Grant missed them. The judge warned him. Grant smiled in court like warnings were compliments. Then, at a deposition, the mask slipped. We sat in a conference room with stale air and a humming fluorescent light. Grant wore a navy suit and a wedding ring he'd stopped wearing when he moved out. He wore it now like a prop, like a reminder of what he thought he owned. The court reporter swore him in. Dana asked basic questions first. Job, income, accounts. Grant answered smoothly, too smoothly, rehearsed. Then Dana slid a document across the table. "Do you recognize this?" she asked. Grant glanced. It was the UCC filing. He shrugged. "Looks like standard paperwork." "Is that your signature here as manager of Holloway Holdings, LLC?" Dana asked. "Yes." "And you created that LLC during the marriage?" "Yes." "And you did not disclose it in your initial financial declaration?" Grant's eyes flicked to Clifford. Clifford coughed. Grant said, "It wasn't relevant." Dana didn't raise her voice. She didn't need to. "Mr. Holloway," she said, "do you recognize the name Eleanor Holloway on this guarantee?" Grant looked at it longer. Something in his face tightened. "It's her name," he said. "Did she sign it?" He smiled. "Looks like it." "Did you watch her sign it?" Grant's smile thinned. "I don't remember." Dana nodded slowly. "Do you remember taking her driver's license to scan for the loan file?" Grant's eyes snapped to hers. "I didn't take anything," he said. Dana's voice stayed calm. "Then how did Harbor Ridge obtain a copy of her license?" Grant's jaw clenched. "Ask them." The room felt electric, the kind of quiet before thunder. Dana leaned in. "Mr. Holloway," she said, "did you ever practice writing Eleanor's signature?" Grant laughed once, short. "That's ridiculous." Dana lifted a page, a bank signature card from a joint account. My real signature. Then the guarantee. The fake. Then a third document, a greeting card he'd signed, "Love, Grant," in the same looped style. 3 samples. 1 pattern. For the first time, Grant looked at me. His eyes were cold. He wasn't pleading. He was warning. I held his gaze and I realized he wasn't afraid of truth. He was afraid of consequences. We left the deposition with more than anger. We left with a timeline, license missing, LLC created, transfer started, loan filed, house payoff requested. It wasn't chaos, it was choreography. Dana brought in a forensic accountant named Miguel Santos. Miguel was quiet, compact, with the kind of patience you need to chase numbers across years. He asked for everything: bank statements, tax returns, business records, QuickBooks files. Grant delayed. Dana subpoenaed. Miguel built a map, and the map was ugly. Northline Logistics wasn't a real consulting client. It was a shell, an entity created to receive marital funds and reroute them. The transfers from the joint account went to Northline. From Northline, money went to 3 places. 1, a brokerage account in Grant's name at a firm I'd never heard of. 2, a crypto exchange account. 3, a payment processor that linked to something called Cedar Ridge Storage. Storage. That word hit me like a door slamming. Because Grant had rented a storage unit the year before he moved out. He said it was for old furniture. I'd never visited it. I'd never seen the key. Miguel found the payments, monthly, consistent, and then a spike. A $8,000 payment in a single month, labeled prepay, like he was buying time, buying privacy. Dana obtained a court order for an inspection, not of the unit itself. Not yet. Just the contract, the access logs, the billing history. Cedar Ridge Storage complied. They sent us a spreadsheet. Access logs showed entries, late nights, early mornings, dates that matched big transfers. And the person entering wasn't always Grant. Sometimes it was a woman, a name I didn't recognize. Marissa Lane. I stared at the name until it felt like it burned. Mistress, assistant, relative, or the person holding what he was hiding? Dana didn't speculate. She simply said, "We subpoena her." Marissa's lawyer responded with outrage. But outrage doesn't erase records. We got her phone number from the file. We ran it through a skip trace service Miguel used. And then the real escalation. The kind that makes your hands sweat even when you're sitting still. Marissa Lane was listed as an authorized user on Grant's credit union account. She also had a mailing address tied to a second property, a small duplex in Tacoma, purchased 7 months earlier in the name of Holloway Holdings, LLC. I felt the room tilt. A duplex. He'd bought a duplex during our marriage, with our money, and hid it. That wasn't just hiding assets. That was building a second life with bricks. Dana filed an emergency motion for additional restraining orders and an order to show cause. We walked into court with exhibits stacked like a wall. Grant walked in with a new haircut and the same smile. He whispered something to Clifford. Clifford smirked. Grant looked at me like I was still the wife he could hush with a hand on my knee. The judge didn't smile back. Dana presented the evidence, the transfers, the LLC, the duplex deed, the storage logs, the unauthorized guaranty. Miguel testified briefly about tracing funds. The judge listened. Really listened. Eyes narrowing as the picture sharpened. When Clifford stood to argue, he tried to paint it as business opportunity and separate property planning. The judge stopped him. "Counsel," she said, "this court takes full disclosure seriously." Then she turned to Grant. "Mr. Holloway," she said, "did you purchase a duplex in Tacoma during the marriage?" Grant's mouth opened, closed. Then he said, "It's an investment vehicle." "That is not what I asked," the judge replied. Grant swallowed. "Yes," he said. "Did you disclose it?" "No," he admitted, voice thin. "Why not?" Grant tried to smile. "I didn't think it mattered." The judge's eyes went flat. "It matters." She ordered him to produce complete financial records within 10 days. She ordered him to appear for a sanctions hearing, and she warned him, in plain language, that hiding assets could result in an unequal division. Grant's smile finally slipped, just a crack, but I saw it. Outside the courtroom, he cornered me near the elevators, not close enough for a scene, close enough for menace. "You're going to regret this," he whispered. I looked at him and spoke softly, so calm it surprised me. "I already regretted trusting you," I said. "This is me fixing it." Before the emergency hearing, Grant tried to stage a mediation. We sat in an office with framed watercolor boats and a mediator who kept saying, "Let's be practical." Grant arrived with pastries, as if sugar could soften fraud. He slid a spreadsheet across the table that listed our marital estate, as if it was a garage sale. 1 checking account, 1 retirement plan, and no other real property. Dana didn't touch the sheet. She asked one question instead. "Where is the Tacoma duplex listed?" Grant blinked, then laughed lightly. "Dana, come on. That's an LLC asset." The mediator nodded like that sounded sophisticated. Dana leaned in. In Washington, assets acquired during marriage are presumed community unless proven otherwise, she said, voice even. Grant's smile tightened. He tried to pivot. He talked about my emotions. He talked about moving on. He talked around numbers the way he always had. Then the mediator asked him to sign a disclosure acknowledgement, just a simple statement that he'd provided complete information. Grant's pen hovered, hesitated, then he set it down. "I'll have my lawyer review it," he said. In that tiny pause, the room understood what I'd been living with. He could lie out loud, but he couldn't sign a lie when it might come back with teeth. We walked out without settling. In the parking lot, Dana exhaled once. "That hesitation," she said, "is fear." And for the first time, I felt it too. Not fear of him, fear in him. That was when I stopped shaking. For a week, I barely slept. I replayed the risks. What if the credit union sued me? What if he destroyed records? What if Marissa vanished? But fear doesn't pay bills. Action does. So I acted. Miguel's tracing continued. He found that the brokerage account had significant holdings, not just cash, but shares in a private EIT and a portfolio of municipal bonds, income producing, quiet, the kind of assets that don't scream, but they whisper monthly. Grant had been collecting interest while telling the court he was cash-strapped. He'd also opened a custodial account in the name of his nephew, likely as a smokescreen. Miguel marked it red. "Common tactic," he said, "to park funds with family." The sanctions hearing arrived like a storm scheduled on the calendar. Grant submitted records at the last minute, partially redacted. He claimed privacy. Dana objected. The judge ordered unredacted copies. Grant's accountant submitted an affidavit claiming mistakes. Dana cross-examined the accountant and revealed he'd been paid directly from Northline Logistics, not from Grant personally, not from a legitimate business, from the shell. The judge's patience thinned, and then, around the 70% mark of my story, the twist hit. Not a dramatic scream. A quiet email from Harbor Ridge Credit Union's fraud department. Donna forwarded it to me at 6:14 p.m. Subject line: Urgent Guaranty Investigation Update. I opened it and felt my pulse in my throat. Harbor Ridge had reviewed the disputed guarantee. They had compared the signature to known samples. They had pulled security footage from the branch where the notarization occurred. And according to their investigation, the person who appeared and signed wasn't me. It was Grant, wearing a baseball cap, standing beside the notary, signing my name in front of a camera. The message continued. Harbor Ridge was referring the matter to law enforcement. They were freezing the line of credit. They were placing a hold on accounts connected to Northline Logistics. And here was the part that made my knees go weak. They were issuing a demand letter to Grant for immediate repayment, citing fraud as a default event. Grant hadn't just hidden assets. He'd built his whole strategy on a loan that could now implode and take his hidden world with it. Fraud turns secrets into shrapnel. Dana called me immediately. "Do you understand what this means?" she asked. "It means he lied," I said, voice shaking. "It means the court now has an external entity confirming misconduct," she said. "And it means his credibility is gone." Credibility. The currency he'd been spending like counterfeit bills was now worthless. We filed the email as a supplemental exhibit. We requested an emergency hearing. The judge granted it within 48 hours. Grant arrived pale. Clifford arrived angry. Marissa Lane arrived, for the first time, sitting behind them, sunglasses on indoors, clutching a purse like a shield. When the judge read the email aloud, the courtroom air changed. You could feel people sit straighter. You could feel the court reporter's fingers move faster. Clifford attempted damage control. "Your Honor, this is an ongoing investigation," he said. "No charges?" The judge cut him off. "This court does not require a criminal conviction to make findings regarding credibility and disclosure," she said. Then she looked at Grant. "Mr. Holloway, did you sign your wife's name on that guarantee?" Grant's voice cracked. "No," he said. The judge held up the email. "Then you are asserting the credit union is lying?" Grant's eyes darted. Clifford whispered urgently. Grant swallowed. "I don't know what they think they saw," he said. The judge leaned forward. "I am ordering you to surrender your passport to the clerk today," she said. Grant froze. "I am also appointing a receiver to manage and preserve assets held by Holloway Holdings, LLC," she continued. "A receiver, a third party with power to seize, freeze, and report. The kind of person who walks into shell games and takes the shells away." Grant's hands trembled on the table. For the first time, I saw him as something other than a storm. I saw him as a man realizing the sky could hit back. The receiver moved fast. Within a week, the duplex in Tacoma was flagged for sale restrictions. The storage unit was accessed under supervision, and what was inside wasn't old furniture. It was inventory, boxes of electronics, high-end earbuds, tablets, smart home devices, sealed, stacked, labeled, a side hustle, a cash business, and tucked in a lockbox, cashier's checks, 5 of them, each for $9,900, just under the bank reporting threshold that triggers certain federal forms. Grant hadn't just hidden assets, he'd structured them. Miguel whistled softly when he saw the checks. "Pattern's obvious," he said. Dana's eyes went hard. "We're going to court with this," she said, "and we're going to ask for an unequal distribution and attorney's fees." I stared at the checks, hands cold. "How long has he been doing this?" I asked. Miguel flipped through the storage contract. "At least a year," he said. "A year of lies, stacked in cardboard." The power began to shift. Not all at once, but like a tide pulling back from a beach. Grant's accounts were frozen in places. His broker flagged suspicious activity. The crypto exchange, when subpoenaed, produced transaction logs showing he'd moved funds to cold wallets. But the receiver's forensic team traced part of it through exchanges that required identity verification. Every secret left fingerprints. Grant had left so many he could have painted a wall. Marissa Lane was deposed, without sunglasses this time. She looked younger than I expected. Mid-20s, nervous eyes, hands that wouldn't stop twisting a tissue. Dana asked her simple questions. "How did you meet Grant? When did you start visiting the storage unit? Did you know about the duplex?" Marissa tried to claim ignorance. But then Dana showed her the access logs, then the authorized user forms, then the lease paperwork with Marissa's name as occupant. Marissa's voice shook. "I thought he was separated," she whispered. Dana's tone stayed even. "Were you aware he was forging his wife's signature?" Marissa's face went white. "No," she said quickly. "No." He said she agreed. He said she was fine with it. I almost laughed. Not because it was funny, because it was absurd. The lies always rely on someone else being invisible. When Marissa left, she brushed past me and murmured, "I'm sorry." I didn't respond. My apology bank was empty. Grant tried one last tactic. He offered settlement again. Bigger numbers, faster timelines. He offered me the house, the duplex, half the brokerage, and a lump sum to make this go away. He also demanded a confidentiality clause. He wanted silence as part of the price. Dana smiled without warmth. "We are past confidential," she said. "We're in consequences." Trial prep intensified. We built exhibits. We outlined timelines. We prepared to show the judge not just that he hid assets, but that he weaponized the system. And then, the part that felt like the universe exhaling. Grant's attorney withdrew. Clifford filed a motion citing irreconcilable differences with client. In lawyer language, it meant Grant had lied to him too, or refused to stop lying, or refused to pay. Whatever the reason, the effect was visible. Grant sat alone at the next hearing with a new attorney who looked like he'd been hired last week. He didn't smile anymore. He stared at the floor. The judge scheduled trial for 2 days. Bench trial. No jury. Just facts, credibility, and the weight of paper. On the morning of trial, I wore a navy dress and a simple silver necklace. Not armor, just myself. Dana placed a hand on my shoulder and said, "Speak clearly, breathe, tell the truth." Truth. The simplest weapon. The hardest to hold when you've been trained to doubt your own memory. We presented our case in a clean line. We showed the joint account transfers. We showed Northline's creation. We traced funds to the brokerage, to crypto, to the duplex, to the storage unit. We showed the forged guaranty and the credit union investigation. We showed the cashier's checks. We showed the receiver's inventory list. We showed the tax returns and the hidden income. Each piece alone could be explained away. Together, they formed a cage. Grant testified. He tried to sound reasonable. He tried to claim he was protecting assets from Eleanor's spending. That made the judge's eyebrow lift. Dana cross-examined him with patience that felt like a blade. "Mr. Holloway," she asked, "did you ever tell this court about the duplex?" "No." "Did you ever tell this court about the brokerage account?" "No." "Did you ever tell this court about the cashier's checks?" "No." "Did you sign your wife's name on a guarantee?" "No," he insisted. Dana turned slightly and spoke one sentence. "Your Honor, may we publish Exhibit 48? Exhibit 48 was a still frame from the credit union's security video. Grant in a baseball cap. Grant holding a pen. Grant leaning over a counter. Grant writing. The timestamp visible. The notary visible. The signature line visible. Grant stared at it like it was a ghost. His mouth opened, then closed. Dana didn't gloat. She simply asked, "Is that you?" Grant whispered, "Yes." The courtroom went so quiet I could hear the air system click. "And what name are you signing?" Dana asked. Grant's eyes filled with something, not remorse, panic. He swallowed. "Eleanor," he said. The judge's face didn't change much, but her voice lowered. "Mr. Holloway," she said, "you have committed a serious violation of this court's trust." Grant started to speak. The judge held up a hand. "I have heard enough," she said. By the time we reached the final stretch, the 85 to 95% power reversal, it didn't look like fireworks. It looked like a woman in a robe writing orders that would reshape a man's world. The judge issued findings on the record. Grant had intentionally concealed marital assets. Grant had dissipated funds. Grant had forged a signature to obtain credit. Grant had failed to disclose real property. Grant had violated temporary orders. And because of those findings, the judge ordered an unequal division. I received the house, awarded as my separate property. with the mortgage refinanced solely in my name and with Grant's interest offset by his misconduct. I received the Tacoma duplex, with instructions to sell or retain, but with proceeds allocated heavily to me. I received 65% of the brokerage account. I received the cashier's checks as part of the marital estate. Grant was ordered to pay my attorney's fees. He was ordered to reimburse the estate for funds he'd diverted. And the receiver was ordered to remain in place until all assets were fully accounted for. Grant's face drained of color as the words landed. He tried to object. The judge didn't look up. "Objection noted," she said, and overruled. After court, Grant approached me again, but this time his voice wasn't sharp. It was hollow. "I never meant for it to go this far," he said. I looked at him, at the man who'd signed my name like it was his. "I did," I replied, "because you were willing to take everything, and I was finally willing to stop you." In the weeks that followed, the practical work began. Refinancing paperwork, receiver reports, sale prep for the duplex, emails with title companies. I learned more about escrow than I ever wanted, but each document felt like a stitch closing a wound. The credit union pressed charges. I didn't have to push them. They pushed themselves, because institutions don't like being used as props. Grant faced criminal investigation. I didn't celebrate. I didn't dance. I simply slept, for the first time in months, without waking up to check my phone. One evening, months later, I sat on my porch with a mug of tea. The Seattle sky was gray, as it loves to be, but the air was calm. My phone buzzed. A message from Dana. "Receiver closed out. Final accounting attached. You're clear." Clear. That word felt like sunlight. I walked inside and looked at the house. My house. And the quiet inside it wasn't lonely anymore. It was safe. People ask me now how I knew he was hiding assets. I tell them the truth. I didn't know at first. I suspected. Then I verified. Then I documented. Then I refused to be rushed into silence. Because when someone tries to hide assets, they're really trying to hide power. They're trying to keep you in the dark so you can't see what's yours. But the dark isn't permanent. Not if you bring your own light, one record, one subpoena, one question at a time. And if you're ever sitting in a courthouse hallway with your hands shaking around a paper cup, hearing someone tell you to be grateful for crumbs, remember this. Crumbs are what people offer when they think you're too tired to stand. Stand anyway. Breathe and start counting what's real.